Hello, welcome to Study Circle. Today we are going to read Class 8 Standard Civics Chapter 4 Judiciary. Judiciary is a system of courts which interpret and apply the law. Any citizen can approach the judiciary when a law is violated. As a third organ of the government, the judiciary plays a crucial role in the functioning of India's democracy. Role of judiciary: dispute resolution. The judicial system provides a mechanism for resolving disputes between citizens and the government, between two state governments, and between the center and state governments. Judicial review. As the final interpreter of the Constitution, the judiciary also has the power to strike down particular laws passed by the Parliament if it believes that these are violation of the basic structure of the Constitution. Upholding the law and enforcing fundamental rights. Every citizen of India can approach the Supreme Court or High Court if they believe that their fundamental rights have been violated. For example, in Paschim Banga Khet Mazdoor Samiti versus State of West Bengal case of 1996. Supreme Court ruled that Article 21 includes the right to health and directed the West Bengal government to pay compensation as well as come up with the blueprint of the primary health care with reference to treatment of patients and during an emergency. Independence of judiciary. Independence of judiciary allows the court to play a central role in ensuring that there is no misuse of power by the other branches of the government, legislature and executive. It also plays a crucial role in protecting the fundamental rights of citizens, as anyone can approach the courts if they believe that their rights have been violated. Our Constitution envisions the independence of judiciary and ensures it by separation of powers. The legislatures and executive cannot interfere in the work of the judiciary. The courts are not under the government and do not act on their behalf. Appointment of judges. All the judges in the High Court as well as Supreme Court are appointed with very little interference from other branches of government. Once appointed to this office, it is also very difficult to remove them. Structure of courts in India. There are three different levels of court in our country: Supreme Court, High Court, Subordinate or District Court. Supreme Court. It is the apex level court for the whole country. It is located in New Delhi and is presided over by the Chief Justice of India. High Court. Each state has a High Court which acts as the highest court of that state. Subordinate or District Court. These are usually at the district or tehsil level or in towns. They have many kinds of cases. Each state is divided into districts that are presided over by the district judge. Integrated judicial system. Following features make our judicial system as an integrated one. Pyramid structure. The structure of our courts from the lower to the highest level resembles a pyramid. Decisions made by the higher courts are binding on the lower courts. Here you can see the pyramid structure of our integrated judicial system, that this one is the lower court, this one is the higher court, and the most highest place is Supreme Court. Appellate system. A person can appeal to the higher court if one believes that the judgment passed by the lower court is not just. Different branches of legal system. The legal system in India is divided into two branches, that is called criminal law and civil law. Differences between criminal law and civil law. Criminal law. It deals with conduct or acts that the law defines as offenses. For example, theft, harassing a woman to bring more dowry or murder. Whereas civil law deals with any harm or injury to rights of individual, for example, dispute relating to sale of land, purchase of goods, rent matter, divorce cases, etc. In criminal law, it is usually begin with the lodging of an first information report, that is FIR, with the police who investigate the crime, after which a case is filed in the court. In civil law, a petition has to be filed before the relevant court by the affected party. Only in a rent matter, either the landlord or tenant can file a case. In criminal law, if found guilty, the accused can be sent to jail and also fined. In civil law, the court gives the specific relief asked for. For instance, in a case between a landlord and a tenant, the court can order the flat to be vacated and pending rent to be paid. So, it is the difference between criminal law and civil law. Now, the accessibility of courts to the people and its issues. In principle, all citizens of India can access the courts in the country. However, there are some issues that hampers the access of justice to common person, that are as follows. That is complexity of legal procedure. Legal procedure involves a lot of money, paperwork and lot of time. This makes the idea of going to court to get justice often remote. To increase access to justice, Supreme Court in nearly 1980s devised a mechanism of public interest litigation that is called PIL. Now, what is PIL? PIL allows any individual or organization to file a PIL in the High Court or the Supreme Court on behalf of those whose rights were being violated. Even a letter or telegram addressed to Supreme Court or the High Court could be treated as PIL. It simplifies the legal process that imparted justice even in untouched areas such as rescuing bonded laborers from inhuman work conditions, securing release of prisoners who have completed their imprisonment period. Mid-day meal scheme is an outcome of PIL. Different interpretation of the fundamental rights. Access to courts is access to justice. However, there are some court judgments that people believe work against the best interest of the common person. For example, the judgment of Olga Tellis versus Bombay Municipal Corporation, that is BMC, established the right to livelihood as a part of right to life conferred by Article 21, while later judgment tends to view that slum dweller as an encroacher in the city. Justice delayed is justice denied. The courts inordinately take long number of years to hear a case. Huge vacancy as shown below in judiciary, particularly in subordinate courts, contributes to it. Now you can see that number of judges in India. The number of Supreme Court is 34, sanctioned strength and working strength 30, vacancies 0. High Court 1079, working state 615 and 655, and the vacant posts are 424. District and subordinate court sanctioned strength is 22,644, working strength is 17,509, and vacancies are 5,135. This data is according to 1st November 2019. Despite these issues, there is no denying that judiciary has played a crucial role in democratic India, serving as a check on the powers of the executive and legislature as well as in protecting the fundamental rights of the citizens. Interesting point of this chapter is that the Supreme Court, it was established on 26 January 1950. Like its predecessors, the Federal Court of India, that is 1937-1949, it was the Chamber of Princes in the Parliament House and moved to its present building in 1958. The High Courts, they were first established in the three presidency cities, that is Calcutta, Bombay and Madras in 1862. The High Court of Delhi came up in 1966. Currently, there are 25 High Courts in India. Some states share some common High Court. For example, Punjab and Haryana at Chandigarh. 4 northern eastern states, that is Assam, Nagaland, Mizoram and Arunachal Pradesh at Guwahati. Some high courts have benches in other parts of the state for greater accessibility, like Lucknow bench of Allahabad Court. Andhra Pradesh, Amravati and Telangana, Hyderabad have separate high courts from 1st January 2019. The subordinate court is more commonly known by many different names such as trial court or the court of district judge, the additional session judge, chief justice magistrate, metropolitan and magistrate, civil judge. Sustainable development goals 16 include peace, justice and strong institution. Thank you.